colleagues, I call this meeting to order. Welcome to our 83rd meeting of the Standing Committee on Indigenous and Northern Affairs. Pursuant to standing orders, today's meeting is taking place in hybrid format. For those participating virtually, you have the choice of choosing the language that you'll be following in French, English, or Inuktitut. And in the room here, we'll turn mics on and off. Anybody who's joining us online will need to mute and unmute yourself as needed. Now that we're in session, photos and screenshots are not allowed. What else do I have here? Before we head out at the end of today or tomorrow when people are traveling home for Remembrance Day, I once again want to remind members that all amendments, including sub-amendments, must be submitted in writing and sent to our committee clerk. Our established deadline is November 29th. And if you wish to propose amendments, you can involve the Legislative Counsel, Alexandra Shora, with your written instructions, and she'll ensure that amendments are drafted in the proper legal format. We have two panels today and resources until 5:35, so that's when we have to end by, so that should help us manage our time accordingly. We'll go through our first opening statements, rounds of questions, suspend briefly, bring in the second panel, go through it, and then adjourn for the weekend. And so as our first panel, we have in person Mr. Tony Belcourt. Belcourt, welcome. And online, we have Solomon Sanderson as a consultant, and we have Danette Starblanket, who is an assistant professor with the University of Regina. So welcome to everybody. We'll get right into our opening statement. And today, I think I'll go, Mr. Belcourt, to you for your 5-minute opening statement, if you're ready. When you want, please proceed. I have also a yellow card, a red card system. So when there's 30 seconds left on the clock, I'll give you the yellow card. When the time is up, I'll give the red card. Don't stop mid-sentence, but wind up your thoughts so we can move on to the next person and the next round of questions. So the time goes by quickly. It's a lot of material to fit into rounds, but we try to get as much out as we can. So Mr. Belcourt, when you're ready, please proceed.
Thank you, Mr. Chair, members of the committee. Makwa Ginichinich, Hanitsi Kasin, Manatus Kayahin, Oche Nia Kyate. I'm Tony Belcourt. My spirit name is the Bear That Leads, a name given to me by former Ontario Regional Chief Charles Fox. I'm from the Métis community of Lac Sainte Anne, Alberta. I've been involved as an Indigenous advocate and leader for nearly 55 years. As a Métis leader in Alberta in the 60s, as president of the Native Council of Canada in the 70s, and as founding president of the Métis Nation of Ontario from 1994 to 2008. I was a member of the Board of Governors of the Métis National Council for 15 years and Métis Nation Ambassador to the United Nations and the OAS for 10 years. I was a member, I'm carried by the pipe. Maternal ancestors of my community are Cree and Sikanese women. They are the grandmothers that gave us our language, taught us our medicines, values, cultures, and traditions. My paternal ancestors are French and Mohawk. In other communities of our homeland, they include the Scots and the English. In Métis communities and other parts of the Métis homeland, our maternal ancestors include the Saulteaux, Dene, and the Anishinaabe. The blood of our ancestors in much of our homelands are the same as that of our First Nations cousins. In fact, the Cree in my area called us Apitaugosan, which means Cree half-cousins. The progeny of our ancestors formed the origins of our communities long before so-called outside control. These are Métis ancestors, although we were not always called Métis. In my case, we were known as Otepimsuak, the people who own themselves. At Lac Sainte Anne, we spoke of ourselves as Nihewak, which simply means the people in Cree. In Saint Laurent, Manitoba, the people there referred to themselves as Limachif. Anishinaabeg referred to the Métis in their communities as Optum Nishnabeg. Governments referred to us as half-breeds. I've heard opposition to Bill C-53 by those who are saying there are no Métis communities in Ontario and that they don't know of any. I'd like to point out that we've had a history of relationships with Ontario First Nations. They include a protocol with the Chiefs of Ontario. Purpose of this protocol was to affirm mutual respect, recognition, and support of our respective rights, interests, and aspirations, to facilitate government-to-government relationships, and establish a political process to strengthen the relationship between Ontario First Nations and the Métis Nation within Ontario. We also entered into a nation-to-nation relationship with the Anishinaabe Nation. It was forged in a traditional way, through a sacred ceremony and an assembly of the Anishinaabe Nation at Kettle and Stony Point First Nation in 2005. We both brought our songs to the drum. We brought our pipes for ceremony. We had a feast, and we danced. During that time, the Anishinaabe Nation and the Métis Nation worked out a harvesting accord to recognize and respect each other as nations and agree to conduct all discussions on the basis of respect and equality. This accord recognized the shared traditional territory, the Aboriginal and treaty rights to hunt, fish, and gather in the shared territory where our people have kinship ties. I've also heard that if Bill C-53 is passed, it would be a detriment to First Nations economically. This is a refrain I heard 52 years ago when I first met with George Manuel, who was then president of the National Indian Brotherhood. It took some time for me to get a meeting with him, and when I did, he said his chiefs didn't want him to meet with me, that the government was warning him not to meet with me. They were saying that there is only a loaf of bread available, and if the Métis were recognized, well, George, that loaf of bread, half of that loaf of bread will have to be given to them. I said, George, Ottawa is not a loaf of bread. Ottawa is a bakery. I told George that we have no interest in the funds that are set aside for you through Indian Affairs. There isn't enough for you, and there's nothing for us. I told him we need to work together to get funds for housing, for healthcare, for economic development. We did just that. I hope that this committee will see through the arguments that have been brought forward to deny the recognition of Métis rights in Canada and pass Bill C-53 so that our Métis and First Nations governments can begin to rebuild that nation-to-nation relationship for the benefit of all Indigenous people. Thank you, Mr. Chair.
Great. Thank you so much for your opening statement. Ms. Stark-Blanket, we'll go to you next. Just so our colleagues know, we've had a connection problem with Mr. Sanderson. He is working on trying to join. When he does get in, he did do his sound quality test yesterday, but we'll need to suspend for a brief moment to just make sure that today's quality is good. We are hoping that he'll be in any moment now, but while we're waiting, Ms. Stark-Blanket, I'll go to you for your 5-minute opening statement.
All right. Thank you. Good afternoon. I come from Starblanket Cree Nation in southern Saskatchewan. I've served First Nations organizations as a First Nations public servant, working at the Federation of Sovereign Indigenous Nations, and for the past several years as a sessional instructor in Indigenous Studies and Political Science, and more recently as an assistant professor in public policy at the University of Regina. I hold a PhD in public policy from the Johnson Choyama Graduate School of Public Policy, and I also hold a Master of Arts in Indigenous Studies through First Nations University of Canada in collaboration with the University of Regina, where I gathered data and conducted research on Treaty 4 in southern Saskatchewan in 2001. This included gathering the oral history of the elders and knowledge keepers, along with other primary and secondary data. Prior to that, I completed a Bachelor of Arts honors in Indian Studies, where I researched the history of my First Nation, including Chief Starblanket's alleged and misperceived involvement in the Northwest Uprising of 1885. Some of the research conducted for my BA honors informed the graduate research for my Master of Arts degree. I'm presenting evidence today related to the historic rights of the Métis peoples, based on my understanding and my training, both informal and formal. Métis people have Aboriginal rights, which include the rights to hunt, fish, trap, and gather, the rights to self-government, and the rights to the land. These are inherent rights based on Métis people belonging to the group of Indigenous peoples. Métis people have asserted their rights throughout the colonial history of this country. In some cases, those rights were aligned with the rights of First Nations people. For example, the Métis were questioning the Crown's rights to occupancy in pre-treaty. The involvement of Métis people at the time of treaty negotiations demonstrates their vested interest in the outcomes that would follow. First Nations and Métis people had very different relationships with one another historically than we do today in contemporary times. The impacts of colonization changed those relationships and damaged kinship ties in very negative ways. Those relationships were familial. We knew our blood ties to one another. Certain Métis people were recognized as having rights as road allowance people during the early reserve years. Many First Nations in Saskatchewan had road allowance people camped just outside the reserve boundaries. In many cases, these were our Métis relatives. In my historical research, I found First Nation people were very concerned with the Métis situation and pressed the Crown to deal with them in a just and fair manner. First Nations people at the time of treaty were insistent that the government deal with the Métis in the same ways they were treating with the First Nations. Métis people were interpreters, advisors, company men, witnesses, servants of the Crown during treaty negotiations. But most importantly, Métis people were the relatives of the First Nations people present. Research demonstrates Métis people were involved and relevant at many of the treaty negotiations. In the case of my research for Treaty 4, the spokesman for First Nations people referred to the Métis presence. In Alexander Morris's textbook, which was reprinted in 1991, provides a written account, albeit a colonial account, of the negotiations for the early treaties and the post-Confederation numbered treaties up to and including Treaty 7. In the Treaty 4 negotiations, the gambler, who was appointed by Loud Voice to speak for him, and he was a principal chief of the Cree, so when he spoke, all listened. Loud Voice later would take up Ochapowace Nation to be the leader at Ochapowace. He told Commissioner Alexander Morris, through the gambler, that certain things were in the way of moving forward in the treaty discussions in Treaty 4. One of the things was earlier that day, the First Nations people had observed Morris was reluctant to shake the hand of a Métis person. This caused a lot of mistrust for First Nations people. The gambler described it by saying, "This morning I saw the chief of the soldiers who asked me, 'What is in your way that you cannot come and meet the Queen's messengers?' Then I told him what was in the way. And now that I'm come in, what do I see? You were rather slow in giving your hand. You said that the Queen spoke through you and spoke very plainly. But I cannot speak about what you said at present. The thing that is in the way, that is what I am working at." And then the gambler continued on with, "I told the soldier master, you did not set your camp in order. You came and stayed beyond over there. That's the reason I did not run in over there. Now, when you have come here, you see sitting out there a mixture of half-breeds, Crees, Soto, Stonies, all are one. And you were slow in taking the hand of a half-breed. All these things are many things that are in my way. I cannot speak about them." Commissioner Morris responded to the gambler with, "We have here Crees, Soto, Assiniboines, and other Indians. They're all one. And we have another people, the half-breeds. They are of your blood and my blood. The Queen cares for them. One of them is here, an officer with a Queen's coat on his back. At the Lake of the Woods last winter, every half-breed who was there with me was helping me, and I was proud of it and glad to take the word back to the Queen and her servants. And you may leave the half-breeds in the hands of the Queen, who will deal generously and justly with them." There was a half-breed came forward to the table. He was only one of many here. I simply wanted to know whether he was authorized by you to take part in the council. I will continue as we proceed. Thank you.
Thank you so much for your opening statement. I apologize for having to interrupt there, but I look forward to continuing the discussion. Colleagues, we're going to suspend briefly. Mr. Sanderson has been able to join. We just need to do a brief sound check with our clerk and the interpreters to make sure that everything's good today. So we'll resume as quickly as we can, but for the moment, we're suspended. We're just getting back into session here. So, yeah, you have the floor now, Mr. Sanderson, if you'd like to go forward with your 5-minute opening statement. And I was explaining to the other witnesses that I'll give a yellow card when there's 30 seconds left. If you see me, red card when you're out of time. Try to wind up at that point. Don't stop mid-sentence. And I'll give you a little bit of extra time if you need it, but we want to get into our rounds of questions. So when you're ready to start, I'll start the clock for your 5 minutes.
Okay, what I did is I reviewed the Métis Nations self-government agreement with the feds and also the Métis Nation Self-Government Act that recognizes the self-government for Métis under federal jurisdiction and law, and the Métis capacity to make treaties and ratify treaties and their citizenship status. Now, the term Métis, the first term, as you already heard, was half-breed. That done something that is not addressed, and they call it a code of silence. The Métis had to inherit their status of Indian status. And when they inherit those inherent rights, they're inheriting the inherent sovereignty of the Indian nations, the inherent rights by sector, like the inherent right to education, health, economics, justice, so on, but the inherent right to title, lands, and resources. Those are inherent rights that we have as nations, Indian nations. They're granted to our nations by the Creator, and they're granted to our peoples by the Creator. That's what the Métis have inherited from their Indian heritage that they have. But they're guaranteed, they're reserved, recognized, confirmed, and guaranteed by the national powers of treaty making and the international treaties that we made. Now, the Métis adhere to Treaty 3 in Ontario, as you know, and we're born with those rights and that status, and we inherit them from generation to generation. Now, on the non-Indian side, they inherited the colonial benefits that the non-Indians have. Criteria for title to lands and resources, for example, in Manitoba, the homesteads that the non-Indians occupied and improved, they met the criteria for having title to lands and resources. Now, the Métis settlements, the Métis occupied and improved lands prior to treaty, but that provides them the title to their lands and resources like you have under your colonial systems. Now, this is one example of taking the best of the inheritance that they inherited from both sides, the Indian and non-Indian side. But the Act goes on to recognize their jurisdiction and laws, and it also deals with the recognition of them having to have their own laws. That means that there has to be a process in place to deal with the interface of jurisdictional law with the Métis governments of the Métis Nation, but also the interface of jurisdictional law with the Métis laws, the First Nations laws, the provincial and federal laws. It also deals with capacity to recognize citizenship. Section 35.2 now recognizes the constitutional distinct recognition of Métis, and the portability of the rights have to be included in the Métis Act. I'm talking about the portability of their inherent sovereignty, their inherent rights and treaties, treaty rights, community, regional, national, and international. And when you do that, keep in mind that the nations make treaties. Treaties do not make nations. So the modern day of treaty making creates governments. If you don't have a government in the first place, what are you doing signing a treaty? When you look at that, then the both parties of the treaties that are going to be made or have been made need ratification and implementation under new specific and unique laws to give them legal effect. Now, there's a bigger picture that you need to be aware of that most people are not aware of. And the court made the decision in Manitoba said the Crown is in a fiduciary relationship with the Métis as a distinct form of Aboriginal peoples that can not be ignored. It goes on to say the unfinished business of reconciliation of the Métis people in Canadian society is a matter of national and constitutional importance. Now you ask yourself, what is that all about? Well, here's what it's about. And most people don't know this bigger picture. When we talk about the comprehensive legal political framework governing Crown Métis relationships, that framework is governed by what? The inherent sovereignty of the Métis Nations, the assumed sovereignty of the Crown, the inherent rights entitled by the Métis Nations, the Crown Treaty Nations, Métis relations, treaty relations, the Royal Proclamation of 1763 that the late Supreme Court Judge Dixon calls it their Bill of Rights that recognizes everything we're talking about. The Constitution Act of 1982, with the Section 35 being a full box and the Section 25 now applying the Royal Proclamation of 1763. And of course, when we look at that, is UNDRIP with now Bill C-15 having to be implemented and United Nations declarations. So when we talk about that recognition of that framework, that broader-based framework, what does it recognize? That framework now governs by those instruments that I just highlighted, and it recognizes the sovereignty treaty relations, Crown Métis relations, nations to nations, government relations, government to government relations, inherent rights, treaty rights relations. The format for implementation then of what that judgment is calling for requires the implementation of that framework respecting political relations, the equality of government, jurisdiction, law, and courts. Métis, government
Mr.
of Métis
Sanderson,
nations.
I
Yes?
apologize for interrupting. We're at the end of the 5 minutes. If there's a concluding statement that you'd like to make, please do so. And then we're going to need to move into our rounds of questions.
Okay, that's about the end of the statement that I want to make, but there's a code of silence that has to be addressed, 500 years of colonial policies that people can't tie together historically from 1493 to 2023. And that's very critical because that's what's being implemented today. Thank you.
Okay, thank you so much. We're going to go right into our first rounds of questions that are 6 minutes each. And first up, I have Mr. Schmale for 6 minutes.
Thank you, Sharon. Thank you to our witnesses on this very important topic. And I have a very short time, so if I jump in and cut someone off, I do apologize, but it's more in the essence of time. Mr. Belcourt, since you're sitting in front of us, why don't I start with you? In our last meeting, we had a conversation with the Métis Manitoba Métis Federation, sorry, and they were indicating that in order to make this bill, I guess in their words better, improve this bill, they had suggested removing MNO, Métis Nation of Ontario, from this piece of legislation. As a founding member of that organization, I would like to get your thoughts quickly on that.
Well, thank you for your question. I'm very sorry to hear that. I heard that, and I'm very sorry to hear it. The Métis National Council has always embraced the Métis Nation, going back to the very beginning. In the Supreme Court of Canada decision, after that decision came down in 2003, Tom Chartier, who was president at the time, said, Sault Ste. Marie is part of the larger Métis Nation. This decision will have far-reaching implications on the larger Métis collective throughout the Métis Nation homeland, throughout Western Canada. The people who stand charged before you today are descendants of the historic Métis Nation, and more specifically, the historic Métis community at Sault Ste. Marie. What is really baffling to me is why the Manitoba Métis Métis Federation would rely on the decision of the Supreme Court of Canada in R.V. Powley so that the people there could enjoy the constitutional right to hunt and fish for food. That's kind of hypocritical to me that you, on the one hand, want to rely on the Supreme Court of Canada's case on Sault Ste. Marie and then turn around and try to say the community doesn't exist.
Some of the justification for that, and I'm reading just from their transcript here, they are talking about membership, some questions around how the MNO works its membership list. Did you want to comment on those concerns?
The Métis Nation of Ontario Registry requires those who register to provide evidence that they are descendant of an historic Métis community. And that registry has been reviewed many times for its veracity and validity.
So I'll quote here from the Métis, Manitoba Métis Federation here, when talking about their membership and how they align their membership. When we questioned them, the quote was, they have I've lost the quote. So they basically, I'm paraphrasing here, referenced, of course, Louis Riel. They referenced the beating that they have, as you do as well, their connection to jigging, that type of thing. Did you maybe want to put forward the membership that Ontario, how membership in Ontario is granted? If you know it off the top, I know you've been...
Membership is not granted on what we wear.
No, that's the quote I'm using from Métis Manitoba. Yeah.
Sorry, I'm just going to pause your clock for a second. Mr. Sanderson, you're not muted, so I just want to see if you can mute. Yeah,
I'll ask you
okay, we
next,
got
Mr.
it.
Sanderson.
We're done. And we'll carry on, so I'll start the clock again for you, Mr. Schmale.
Thank you. I guess the point I'm trying to make is when asked that question, the Métis in Manitoba, that was basically the answer. I've lost the quote here, but it was basically the answer in a roundabout sort of way. So I just want to, talk about how Ontario looks at their members and determines their membership.
Well, as I said, our people are from historic communities that existed prior to outside control. And as per the guidelines in Pauli, these are the people who are entitled to enjoy a constitutional right.
Okay.
And
Mr.
our
Sanders?
people provide that documentation and it's been reviewed many times, and I'm sure the MNO would say, fine, if you want to come and review it again, go ahead.
Okay, perfect. I just want to get Mr. Sanderson in there.
I've asked him to unmute. He has to.
Can I get my time? Can you hold the clock on that? Yeah. I think we lost quite a bit
Mr.
of
Sanderson,
time.
yeah, if you're able to unmute yourself now. Stop. There, it looks like you're unmuted. You want to give it a try?
Okay.
Yeah, you're good.
Can you
You're
hear
good.
me?
Yeah, you're good.
Okay. Okay, what is your question?
Yeah, give it to him, Jamie, and then I'll start the clock.
In regard, clock started now?
He's going to wait until you.
Oh, thank you. Okay, thank you. It was in regards to membership. I didn't know if you had a question on that or a comment.
I certainly do. It's up to the Métis Nation and the Métis people to identify all their inherent rights and their status. And when they do, they interpret those rights based on their own worldview and philosophy, traditions, customs, practices, values, and beliefs in the Métis language. Then there's duties and collective and individual duties and responsibilities to all those inherent rights, including the Métis sovereignty, inherent sovereignty. When they know all that, then what are their plans and strategies to implement their inherent rights by sector? Inherent right to education, inherent right to health, the Métis inherent right to justice, to economics, and looking at your whole economy. That's community-based, regional, national, international, with all your inherent rights and treaty rights intact in every sector of the economy, with resource, with ownership and benefits identified through the Trade and Commerce Act of the Métis Nation. And once you do that, you have your special laws and policies that implement your inherent rights and the Métis identification of their status. But some Métis have legislated their own Citizenship Act and laws. And one guy from Ontario came from a Métis community here to Saskatchewan, and he was denied Métis status. Well, what's the Métis doing, rejecting their own portability of their status and their rights that I just talked about earlier? They have no authority to be doing that. They have to change their Citizenship Act so that they respect the recognition of the Métis, no matter where they are in Canada or outside of Canada. that portability of the Métis status and rights are critical. So the Métis Nation has to come together. And remember earlier I said Métis Nation has to deal with the internal interface of jurisdiction and law. Well, you already put your finger on one of the issues that will impact on the Métis Nation and Métis government, respecting citizenship and membership, on how they implement it to complement the special rights and status of the Métis and the portability of their rights and status.
Mr. Sanderson, I'm going to need to stop here. We're a bit over the time. I do need to get to my next witness, so thank you so much. Ms. Atwin, you're next with 6 minutes on the floor. And Mr. Sanderson, you might want to just mute yourself again until we get going. Thank you.
Great. Well, thank you very much, Mr. Chair, and it's wonderful to be back at INAN. It's good to see everyone, especially for such a historic study. And I thank you so much for our witnesses for being with us today. On Tuesday, we heard from Métis lawyer Jason Madden, and he asserted that the two clear goals of this legislation are for recognition and affirmation, and then the legal framework for future treaty making. Would you agree with those assertions as kind of the key principles of this bill? I'll direct that towards Mr. Bellecourt.
That's my understanding of them.
Okay. And so we've heard concern over the potential for or the perceived potential for supremacy of future treaties over other existing agreements, as well as a lack of oversight by Parliament. What do you say to those assertions?
Would you repeat that?
Sure. So some of the concerns we've heard is that this future treaty-making process would have a lack of parliamentary oversight and could also potentially have these agreements be superior or be seen as given that supremacy over other existing treaties or agreements. And what would you assert to that?
Well, in any treaty-making process, there's two sides. I'm sure that the federal side is going to make sure that they're not going to be overpowering another treaty. In the treaties, the process that has been set aside, or the precedent established for treaty making in Yukon, is the one that, as Jason Madden said, is the preferred one for us, and I certainly support that.
Would Mr. Sanderson or Ms. Starblanket like to add into to that question?
I can address that.
Great.
I mentioned earlier that nations make treaties. Treaties do not make nations. So the current ones that are in place, like the Yukon Treaty, that's a treaty creating governments of the nations. That's saying that they didn't have government to make treaty in the first place. So keep in mind, it's the national powers of treaty making you're talking about, the governments of our nations. And they have the powers to implement those treaties under their jurisdiction and law, give them legal effect, not just ratification. So yes, there'll be overlap in many areas that has to be addressed. Now you're back to that issue I mentioned earlier, the interface of government, jurisdiction, and law, and the national powers of treaty making and the implementation of treaties respecting territorial boundaries, lands, and the treaty rights in every sector have to be addressed formally under your jurisdictional laws. So when do you deal with the interface of jurisdictional law between the Indian nations and the Métis nations, the federal government and the provincial governments? A treaty process is not valid in terms of dealing with these political issues I'm talking about. And that's what the judgment said. You have to rectify the Métis relations with the sovereignty of Canada and the Constitution. Well, your problem is that most people don't know what that framework is all about. That's been my experience. Even members of government, parliament, ministers, and the oppositions, they don't know what that framework is about. It is there since 1982. You're still implementing the BNA Act of 1876. Well, that's the comment I have, but let's understand what the national powers of treaty making are We talk about treaties and treaty rights. We never talk and discuss about what the national powers of treaty making are. Yet they're very valid. That's one of the national powers of governing. And the national powers of governing are governing internal, external, and international affairs. The self-government policy provides only governing internal affairs. Well, that's not the inherent sovereignty. The inherent sovereignty provides for the recognition of your jurisdiction for the internal, national, international political affairs and governing affairs. That's my position regarding what the issue you're talking about. But when do we go to that political agenda and elevate this administrative legal agenda to a political agenda dealing with these major political agenda items I'm talking about that I've tabled with you? And by the way, I provided you the inherent charts, inherent rights charts. I provided you with a comprehensive legal political relations chart and the self-journey of self-termination under the 500 years of colonial policies in a document that highlights those in about 2 pages. So you have those charts.
Excellent. Thank you very much, Mr. Sanderson. I only have about 30 seconds left. So I just, you ate your flakes today, but as we say where I'm come from, you ate your Wheaties. So thank you for bringing your best energy and thank you for that response. Thank you very much.
Okay, thank you. We're going to go next to Madame Gill. And I expect that the questioning may be happening in French, and so if anybody needs to select another language, English, if you're not bilingual, do that on your controls. And Madame Gill, whenever you're ready, the floor is yours for 6 minutes.
Merci, Monsieur le
Thank you very much, Chair. Thank you to the witnesses for being here with us today. And I know that this is a very current subject, and my colleague said earlier that this is a historic moment, but there are still challenges that we have to deal with. Maybe to start, perhaps with Mr. Belcourt, you mentioned that you were hoping that we could better define your situation, the situation of the Métis, despite contrary arguments. I wonder if you could talk about these arguments with regard to the status of Métis and the differences, and what would you want the committee to know about this situation?
I think there might have been something lost in the translation. I didn't quite understand the question.
I'll stop the clock.
Merci beaucoup, Monsieur le Président. Je vais essayer d'y aller plus rapidement.
Thank you. I'm going to not speak too quickly. So I was wondering, you mentioned earlier that you hope that the committee would be able to better understand the arguments made against C-53. And I would have liked to hear your opinion with regard to those arguments, and what would you like the committee to know about those arguments from your point of view?
Well, I think the argument against the bill, that it is going to impact on the economies, for example, is that what you mean?
En fait, ce sont les arguments contre que.
These are the arguments against C-53. You said you wanted us to be able to see through these arguments, and I wanted you to have an opportunity to answer the arguments of those who are against status for all Métis and also against C-53. And what would you reply to the arguments against C-53?
Well, the arguments against the recognition of the Métis people, specifically the Métis of Ontario, I can only suggest that, first of all, that there have been a lot of agreements that have been established between governments and the Métis of Ontario, based on the legitimacy of our people and our communities, the historic reality of our communities. People are saying there are no Métis communities in Ontario. Well, in the case of Sault Ste. Marie, I mean, do you not trust the decision of the Supreme Court of Canada that firmly established or agreed with the decision of the judge at trial that the community very definitely did exist? And the decision at trial was that governments have an obligation, have a duty to make arrangements with the Métis, with the rest of the Métis. We don't need to go to trial for every single community. Surely, that's not what needs to be done. You know, a precedent has been set. The trial judge, the Supreme Court of Canada said this is the criteria for a community exercising a right.
Je ne veux pas vous interrompre, je sens de tellement peu de temps et j'ai peur.
I don't think I've got a lot of time left, but I'm going. Thank you. Maybe you could provide other information to the committee as well. And do you have any anything else to say with regard to the legitimacy of the Métis, and is there anything else that you would like to say to the committee, or anything you would like to highlight with us, information that you think we should have with regard to that controversy?
Present a written submission with 10 pages. So I'm going to address the issues one at a time in that paper.
Alors, je vais pouvoir me tourner vers peut-être Madame.
So now I'll turn to Ms. Starblanket and give her an opportunity to answer, give her opinion with regard to the same issue. We've heard Ontario, and now I'd like to know what the response is from Saskatchewan with regard to the adoption of C-53.
Thank you. I believe that, when we're looking at what's happened with colonization throughout our history, we've seen a real breakdown in those relationships, and we've come to compete with one another within First Nations communities and between Métis and First Nations, and from Métis to Métis community. So this is part of our colonized face now. This is who we are. We've got to work to decolonize those ways of thinking. I think that we have to understand that upon contact, we started to create, of course, Métis societies, Métis culture came to be born, and from there came communities. And Métis folks were all over this place that we now occupy here in what is today called Canada. So they did occupy these regions. They moved amongst these regions. As I mentioned earlier, they were very involved with First Nations people. And as far as trappers and hunters, they were taking up those avocations as well, those ways of life, and surviving from them. So I think that historical existence has to be understood and has to be realized. I think we also have to realize that we have come to break each other down. That's who we are today, is tearing each other apart. Unfortunately, that's where we're at, and we've got to heal that. We've got to move towards changing that. I hope that's where we're at. So I think the arguments against C-53. I think there's people that will put those arguments forward, but I think we have to look at that history and those Supreme Court decisions that have been made, and the positions of the Métis people, their voice, their oral history is really important. So I think that all has to be taken into account. As far as talking about
Sorry,
recognition.
I'm going to have to jump in. We're at the end of the 6 minutes, and I do have another person waiting. So we need to jump now to Ms. Idlut. And when you're ready, Ms. Idlut, the floor is yours for 6 minutes.
Hoyaname sevodlang me koyarego mabase kayun na kasi unikaron naktuin na lusiklo uvatino pimagerong ni ukadlaktuin na kasi aksoro tusang naktumit.
Lori, just 1 second. We're not getting translation, so I'm going to read.
I'm sorry. Okay. Can we hear me now? Okay. Thank you. First of all, I want to thank the witnesses for coming here to make your statements, because what you have brought to us today is very important. First, I want to ask Tony Belcourt. You were involved in the Pauli decision when you were president of the MNO. At this committee, there have been some disagreements on what Pauli means for Métis in Ontario. Can you tell us who does Pauli apply to? If you could answer that, who does Pauli apply to?
The case of R.V. Pauli is about whether or not the Métis person in that, or people in that case, Stephen Roddy Pauli, had a constitutional right to hunt and fish for food. The constitutional rights of First Nations have gone through the Supreme Court various times, dealing with various questions concerning their rights. The Supreme Court upheld a decision that the rights of the Métis at Sault Ste. Marie were not extinguished. As you know, the Constitution, Section 35 says, the existing treaty and Aboriginal rights of the Aboriginal peoples are hereby recognized and affirmed. Our rights were previously denied as existing by governments. So at the Supreme Court, at the case in Pauli, we proved that the rights of the Métis people at Sault Ste. Marie were not extinguished by the Robinson Treaty. Contrary to the desire of the First Nations chiefs at the time to include the Métis people in that treaty, they were denied specifically. So the court decided, because of that, the rights to hunt and fish for food were not extinguished. Well, of course, so that then leads to the question, if the right to hunt and fish for food wasn't extinguished, well, what about all the rest of the rights? So the rights of our people throughout the Métis homeland, now with regard to the right to hunt, fish for food specifically, is very clear. They have that constitutional right. We now need to elaborate with governments on other rights that exist. Now, our right of self-determination is another right that is understood and recognized widely. We need governments to have the tool to change their laws to accommodate our right to hunt and fish, or our right for self-government. That's what Bill C-53 is all about. And that bill will specifically relate to the Métis Nation in Ontario, in Saskatchewan, and Manitoba.
Thank you for your And so now my next question is to Janet Star Blanket. You were talking about Métis Nation existing within Canada. Occupation.
I think that that history of occupation leads to the right to have self-government.
Thank you. Absolutely. There is absolutely no doubt whatsoever. Métis have the right to self-government, the rights to the land. They require a land base in order to operate as a government. At the time of treaty, the Crown was trying to keep them from this. They prevented, as you heard Mr. Belcourt say, in the treaties, we know in Treaty 4, they prevented the Métis from being what we referred to as treated with at that time, to be receiving the same rights that the Indians, the language used at the time, were receiving. So we were very concerned about their existence, about their rights as First Nations people. We wanted our cousins to be dealt with properly, not to be ignored. They absolutely are entitled to the right to self-government, to rights to the land, rights to land bases, not just the right to hunt and fish and gather, the rights to hunt, fish, trap, and gather. All those Aboriginal or inherent rights, some people will refer to them as, because they are Métis people. They are of our blood, period. There's no question whatsoever. They haven't been dealt with properly or since contact.
Solomon Sanderson isang akawabit.
So Solomon Sanderson, you had your hand raised, so I am giving you this opportunity to respond as well.
Less than a minute, so if you could give your thoughts briefly.
You hear me
then,
now?
Yeah, you're good. Yeah, you're good now.
Yeah, I just wanted to say that, yes, you inherited your status in terms of your sovereignty, all your inherent rights by sector, like I mentioned earlier, and your inherent title. So the Métis Nation has all that, but you're not implementing them. That's the responsibility of the Métis individually and collectively to come together on how you implement them under your jurisdictional law. And you got to elevate your agenda from an administrative agenda to a political agenda, dealing with your political relations, your treaty relations, your judicial relations, your economic relations, your fiscal relations, and your international relations, along with your inherent rights and treaty rights relations. That's the agenda that you need politically to the questions you're asking, because you need political answers, not administrative technical answers from the courts or from bureaucrats. You need to resolve that politically between your governments, the Métis Nation and the federal government, and between the Indian nations and their governments. Now, we only occupy, technically, in terms of title to land and resources as Indian nations today, 2% of the lands of Canada. Now, who the hell are we sharing all the rest of the land and resources with? If we can't have the Métis get their fair share of land and resources in Canada, there's something wrong with us. They're entitled to it. So it's time we talked about it politically, and that agenda has to be addressed politically.
Okay, I'm going to jump. Yeah, I'm going to jump in, Mr. Sanderson. That's at the end of Ms. Idlut's time. We do have another panel that we need to get set up, and so we're going to have to end this panel now. I'd like to thank our three witnesses for being here, Mr. Belcourt, Ms. Starblanket, and Mr. Sanderson. And we'll end this part of the session. I'm going to suspend, and then we'll bring in our second panel, do that as quickly as we can, and then get right into our second round. And we'll be going no later than 5:35. So that's the plan, and for now, we are suspended. Okay, welcome back, everyone. We're now back in session, and so I would like to welcome our second panel. And since everybody's in person, I'll just go through a couple of things. Now that we're back in session, no photos or screenshots are allowed. You do have the option of translation on your consoles in front of you, and if you have any questions, our clerk can help you with those. What else do we have? Well, I think all of you were here for the last panel, so you see how it kind of goes. I'll do the same thing again, 30 seconds for how much time is left, and then red when the time is up. And it's just so that we can keep the flow of the conversation moving, but don't stop mid-sentence. Finish your thoughts when you have the floor. We have lost one witness. We're trying to locate the fourth panelist for today. And so our clerk is, we had been in contact, and we're hoping that she's at security or something. So, but we're going to get started with our three witnesses, so thank you for being here. We have, first of all, Chief Linda McVicker from the Anamaki Wazing 37 First Nation, and please help with any pronunciations or mispronunciations that I might have made. We have Steve Miyawasagi, Council Member, First Nation Band, and Ronald Quintel, the President of the Fort McKay First Nation. So welcome to the three of you. And we'll go through 5-minute opening statements. And so, Chief McVicker, if you're ready, I'm happy to turn the floor over to you, and I'll start the clock when you start speaking.
Okay, thank you. Zigwanikwe Indigenous Muz Dodem Anam Kiwajeng Donji. Good afternoon, members of the Standing Committee on Indigenous and Northern Affairs. I am honored to be here on the unceded territory of the Algonquin Nation to speak of matters that strike at the heart of Canada's relationship with Treaty 3 and all treaty territories in Ontario. My name is Linda McVicker. I'm the elected chief of Animkiwajing First Nation, part of Anishinaabe Nation in Treaty 3. Do you know what a cuckoo's nest is? A cuckoo actually doesn't build its own nest. It instead lays its eggs in other birds' nests. And that is what's going on here. Métis have used our Anishinaabe kin with mixed European ancestry to insert themselves in our treaty, misrepresenting themselves in an 1875 half-breed adhesion. Ask anyone with mixed heritage today if that makes them less Anishinaabe. I say unequivocally, this has nothing to do with the separate Métis people in Treaty 3. It has everything to do with Anishinaabe self-determination of their citizenship in 1873 that resulted in the 1875 adhesion in Treaty 3. I am here to ask that this bill not pass. This bill is contrary to your own constitutional law and to your treaty relationship with us. Allowing this bill to become law would be wholly inconsistent with the honor of the Crown. It would make a mockery of my community and the nation's Aboriginal and treaty rights recognized under your Constitution. This bill is contrary to your constitutional law because it creates a doorway to the right to self-government for groups who don't have the history that your Supreme Court has made clear must necessarily be the foundation for this inherent or creator-given right. Parliament does not have constitutional authority to create constitutional rights where none exist. Yet this is exactly what this bill tries to do. To be clear, UNDRIP does not create rights. It is a recognition of the inherent jurisdiction of pre-existing nations and treaties that exist between Indigenous people and the Crown. Section 8 of the bill says Canada recognizes Métis governments set out in column 1 of the schedule as being authorized to act on behalf of Métis collectivities set out in column 2, and that these column 2 collectivities hold the right to self-determination, including the inherent right of self-government recognized and affirmed by Section 35 of the Constitution. Who are these column 2 collectivities in Ontario? They are collectives of non-status Indians from our First Nations who have been allowed to belong to the Métis Corporation in Ontario. This includes the so-called Northwestern Ontario Métis community who claims rights through our treaty. There was no distinct Métis community and no Métis Nation living or governing within Manitou Acquis when we entered into Treaty 3 with the Crown. There were the half-breeds living amongst us who were part of our Anishinaabe Nation. In its Pali decision in 2003, your own Supreme Court established criteria for identifying Métis communities that could have Section 35 rights in your Constitution. There must be a group with a distinctive collective identity, living together in the same geographical area, sharing a common way of life with some degree of continuity and stability, and this distinctive collective identity in a specific geographical area must have been well established before effective Crown control in that area. The Northwestern Ontario Métis community does not meet these criteria, yet this bill would recognize them as having Section 35 rights. Section 35 is not a melting pot. We don't all wait and see what each other proves as rights and say, yes, me too. Self-government is an inherent right. It must come from being a nation and having your own laws in Ontario that did not happen for any Métis community. And in Manitou Acquis, it could not happen without our consent. Canada will break its commitment to Treaty 3, irreparably harming our relationship if there is a Section 35 treaty made in Manitou Acquis with the Métis. The bill requires no due diligence and no consultation to Treaty 3 before a treaty is entered into and comes into effect. It does not even permit parliamentary oversight. The minister's job is not done here, and he should be questioned about allowing this cuckoo's nest. Our kin with mixed ancestry is a fact of First Nation history and cannot be the basis of an inherent right to self-government. This bill is problematic and must not go forward. The honor of the Crown demands this. Truth must come before reconciliation. Miigwech.
Thank you, Chief McVicker, for your opening statements. I'll go next across the table. So, Mr. Quintel, if you're ready for your opening 5-minute statement, please, the floor is yours.
Thank you. Tanse, ni Ron Quintel, Fort McKay Métis Nation of Sigasun. My name is Ron Quintel, and I have been the president of the Fort McKay Métis Nation since 2005, the authorized government of the Fort McKay Métis community. I am also the elected chairperson of the Alberta Métis Federation, a collective of 8 independent Métis communities. My community is located in northern Alberta, between Fort McMurray and Fort Chipewyan. Our Métis community traces its history to the original forts established by the French traders in the early 1800s amidst the Cree and Dene peoples that inhabited what is now northern Alberta. The present-day community can trace its lineage directly to the original families of Bouche, Piché, and Tourangeau. The Fort McKay Métis community has persisted together for over 2 centuries as a people. Our members continue to engage in harvesting as their ancestors did, and our members continue to look to each other for leadership and support. For this reason, our community began incorporating various bodies to formally represent our community, including the Red River Point Society, established in 1970, the M&A Local 122, established in 1992, and M&A Local 63, established in 2002. At the time our community incorporated M&A Locals, and the Métis Nation was acting as a Métis advocacy group. That all changed around 2016 when the M&A changed from working to assist Métis communities to asserting itself as a government over those communities. That may have been welcomed by some communities, but it was not welcomed by ours, and not to those of so many other Métis communities throughout Alberta. The M&A's constitution, prompted by its negotiations with Canada, asserts that the M&A and its successor, the Métis government, represents the Alberta Métis and all Métis communities. Fort McKay and other Métis communities have made it very clear that this assertion is not true. Despite that, Canada agreed to the same assertion, being entrenched in its February 2023 agreement with the M&A, which states that the M&A is the government of the Métis Nation of Alberta, which is defined as comprising both registered citizens and the Alberta Métis communities whose members are entitled to become its citizens. Imagine a foreign nation suggesting it had authority to speak on behalf of not only its own citizens, but Canadian communities simply because those community members could join that nation. Bill C-53 now proposes to give Parliament's blessing to this hostile and undemocratic takeover of Alberta Métis communities by formally recognizing in Section 8 of the draft bill that the MNA is an Indigenous governing body that is authorized to act on behalf of the Métis Nation within Alberta. I come to this committee on behalf of the Fort McKay Métis Nation to alert this House that the federal government does not properly understand the Métis of Alberta, and that Bill C-53 is based on a flawed understanding that the MNA represents all Métis communities in Alberta, which it does not. In its present form, Bill C-53 is a threat to the Métis communities in Alberta and represents a massive step backwards, not forwards, towards reconciliation, because it threatens to unilaterally assimilate all Métis and Métis communities under an organization which lacks the consent of the governed. If this committee declines to recommend rejecting this bill, Fort McKay Métis Nation asks that you instead amend the bill and expressly limit the recognition granted by Parliament in Section 8 such that it confines the recognition of those Métis communities that have collectively and democratically chosen to be represented by the listed Métis government. To be clear, if this passes in its current form, we will fight it in court. We will not be governed by the MNA, and this Parliament cannot legislate away our sovereignty. To attempt to do so is not only paternalistic, but would represent a huge blow towards the efforts of reconciliation. We have had to fight the MNA for our identity, for our right to exist. We have had to use the courts to do so, and we have won at every court case. All this while the MNA had no rights of recognition. I fear to see what will come if Canada passes this bill and the MNA have the rights that are recognized. We will be there to stand our ground and continue to defend our Métis communities. And we will defend this to the very end. Thank you. Hi, hi.
Excellent. Thank you for your opening comments. And lastly, we will go to Steve Miyawasagi. So when you're ready, the floor is yours.
Thank you, Chair. Good afternoon, everyone. My name is Steve Miyawasagi. My number is 201-00-36101. I am an Anishinaabe from the Serpent River First Nation here in what is now known as Ontario. I come here today to support Métis people in their fight to have their rights recognized, but most certainly I'm here to support my lovely wife, Donna Grenier. She, like so many other Métis people, are feeling persecuted at this time by the Indian chiefs opposing this bill. I know of some Métis people who have decided it is better to be an Indian under the Act than to be Métis. But there are also many, like my wife, who say she is Métis and will always be Métis, even if given the chance to become Indian. In 1848, Chief Shengwak offered the Métis community in Sault Ste. Marie an opportunity to join his band. History teaches us that only 4 of them agreed to join. All the other half-breeds said they were Indian enough without binding themselves under the chief. Those people that joined were also his in-laws, children-in-laws. To me, this says a lot of who they are, who my wife is, and what it means to be Métis. I believe if this bill was passed into law, this would help Métis and Indians to work together for the greater good, like the chiefs many years ago had envisioned. I am not sure what impact my statements will have on my nation, other nations in Ontario, but I strongly believe this needs to be said. I will accept the consequences that may or may not come my way for speaking my truth for the Métis Nation. Many of our ancestors have lost their identity through assimilation, and this continues today. My great-great-grandchildren may never know they had a Native person in their lineage because of the Indian Act. This bill provides hope that someday Canada will allow all Indians to identify who our citizens are, and self-determination for us will become law. This is an important step in Canada's path towards reconciliation that will protect our lineage. When we are here discussing this legislation, we must think about the next 7 generations. We are seeing today the outcomes and repercussions of the government not recognizing Indigenous rights over the last 150 years, and we need to make sure we are not ignoring these rights again. It is always very emotional for me to speak about the next 7 generations, knowing that there may be ones not yet born who will someday look back and say, someone was thinking of me. This is how we live by the 7 generations, the 7 grandfather teachings. This is not about a land grab or hunting rights. This is about who they are. I can't decide for other people what they believe in, but I need to stand up and support the Métis who want self-determination, as I want, and I know many of us want for our communities. This is about Canada recognizing Métis rights that were acknowledged in Section 35 of the Constitution after robust consultation with the Indigenous people across the land. It's clear that there are complex and deeply rooted issues that need to be addressed to ensure justice, reconciliation, and self-determination for all Indigenous communities. The issue of recognizing the rights and identity of Métis people is an important one. Métis people have a distinct culture and history, and acknowledging their rights and self-determination is crucial for fostering unity and understanding among all Indigenous communities in Canada. The struggle for self-determination, cultural preservation, and the recognition of Indigenous rights is ongoing, and it's important for governments to work collaboratively with Indigenous nations to address these issues. The concept of nation-to-nation-to-nation discussions is a step in the right direction, as it can help create a framework for meaningful dialogue and collaboration between Indigenous peoples and the Canadian government. This is our way. We have seen this with the nation-to-nation relationship between the Métis and the Anishinaabe in 2005. It's essential for the government and society as a whole to listen to the voices of Indigenous people, support reconciliation efforts, and take meaningful steps towards addressing historical injustices and improving the lives of Indigenous communities. The journey towards reconciliation is ongoing, but it is a path that can lead to a more inclusive and equitable Canada for everyone. I hope this committee understands their important role in ensuring both the passage of this bill, but also their role in ensuring that we are not pitting Métis and First Nation peoples against each other. We must remember that we are still navigating a colonial system on our path to reconciliation. Doing what is right is often never easy, but this path is an important one. Thank you.
Great. Thank you for your opening comments. We'll get right into the round of questions, and first up I have Mr. Schmale, who will have 6 minutes on the floor.
Thank you, Chair, and thank you to our witnesses. Very important topic. Lots of questions, short on time. Mr. Quintal, maybe I'll start with you. Given your words today and your position not only with Fort McKay but also the Alberta Métis Federation, did you relay these comments to the government when they consulted you about this legislation?
Thank you for the question.
Oh, your mic's not on.
Oh.
Yep, there it is.
There we go. Thank you for the question. The quick and easy answer is absolutely. Throughout the entirety of the process to reach this draft of the bill, we sent multiple letters to the federal government opposing and requesting consultation in relation to what this bill could look like. And throughout the entirety of that process, up until February of this year, was the only time that the federal government actually reached out to have a discussion after they had signed the agreement. So I guess the shortest way I can answer it is that throughout the entirety of the drafting of the bill and the discussion throughout it, there was zero consultation with my community nor the other 7 Métis communities of the Alberta Métis Federation.
So just to confirm, you had to request consultation?
Yes, we have.
Okay. So it wasn't just forthcoming. Until after February, as you mentioned, the agreement was signed.
That is correct. Throughout the process, we wrote letters. We were in contact we tried to contact the Ministry of Indigenous Relations, and unfortunately, there was just no reciprocation throughout the process.
So in your comments, you talked about the Métis Nation of Alberta. If this legislation passes as it would then, in your words, basically assume membership for all Métis in your area and elsewhere. Looking at the text, though, it isn't really clear where that is. Maybe you could expand on that.
Well, I think the biggest issue for us in relation to this is that the Métis Nation of Alberta, under their constitution, the Apimtwist-Timisoaq Métis government that they held a referendum for last year, that will bring, and C-53 will bring that constitution into force. They basically claim all Métis in Alberta, whether you're card carrying or not, whether you are a member of their organization. They've essentially made very clear that they will be usurping their authority to come into your community and to make very clear to government and industry that they are the sole representative. Now, with that said, we've dealt with this same behavior. We've dealt with this same way of doing business with the Métis Nation of Alberta without any rights recognition, without any legislation in place. And we've had to battle that throughout the courts for the last number of years, at least 6 years, with multiple legal cases. Every one that we've won. So what terrifies me is if this legislation is brought into effect without limitations or amendments to be taken into serious consideration, my fear is an M&A without, the Métis Nation of Alberta, without rights recognition, already cost my community $500,000 in court costs. What would a Métis Nation of Alberta with rights recognition do? And that's what scares me and terrifies the rest of the independent Métis communities in Alberta.
Okay, and just to confirm, I did a bit of research, and so your community has actually bought land, and so you have, I guess, a jurisdiction that you're responsible for.
That's correct, and we've declared self-government. We have a constitution. We own all of our own lands. We bought them fee simple from the government. Had to go out and get mortgages to do so. We own all of our own homes. We deliver all of our own programs. We deliver all of our own employment, social services, 100% through the dollars that we've been able to generate from the energy industry. The reality for us is that we've already asserted our rights. We have the lands for those assertions, and it's within our traditional territory, which we have asserted in partnership with the Fort McKay First Nation, to whom we share an almost identical traditional territory. So to say, I guess the easiest way to answer it, Mr. Smale, is that yes, we already have the infrastructure and the government, if you would, in place to be able to represent our people.
Okay, thank you very much. I want to go quickly to Chief McVicker, if I could. In Ontario, I guess some of the testimony we've heard in this series of meetings as we study this bill has been around membership with the Métis of Ontario. You referenced it a little bit in your speech. Is there any amendments that you would be comfortable with to satisfy some of the concerns you have?
I would say no. This treaty that's mentioned in the bill is about land, and it has to be if it's a self-government-based agreement. So the Anishinaabe Nation in Treaty 3, when we asked Canada to explain to us what information it's relying on in entering into these agreements with claimed Métis within our treaty territory, and when we asked them, we've been stonewalled. So Canada's shown to us it is not interested in protecting our interests. And by way of a very specific example, my First Nation has been negotiating a treaty land entitlement claim for a long time. And it's essentially a land claim. And the Northwestern Ontario Métis community wanted the Schedule 2 call activities, and the MNO claimed that they have land-based rights in all of Manitoaki.
So just to clarify, this piece of legislation, it only talks about the governance of these organizations, these three organizations.
Sorry, and before you answer, I'm just going to have to say we are at the end of the 6 minutes, but if you'd like to do a brief response, then I'm going to move to the next member for their questioning.
Well, lands or no lands, Canada must do its due diligence and make sure it's not recognizing Section 35 rights of groups who do not have those inherent rights.
Thank you. We're going to go over to Mr. Batiste next, and the floor is yours for 6 minutes.
Thank you for that, Mr. Chair. And you know, it's interesting. We've talked about the Constitution quite a bit in these discussions over the past few weeks, and as colleagues are on all sides, we're just trying to find a way to recognize something that has been a long time coming, of more than 100 years, as well as making sure that we're hearing from all concerned parties. But when we talk about the Constitution of 1982, it's important to realize that Section 35 recognizes First Nations, Inuit, and Métis. But it goes further on that with Section 35. It says that the existing rights of Aboriginal and Treaty of the existing rights are hereby recognized and affirmed. And there's a key line in there, because my father was part of the negotiations as existing. The government said, yes, these treaties, we can read them, we know that they're there, but we don't know if they still exist. And so a lot of the litigation that has gone forward on Section 35 has been proving that these rights still exist. As the Mi'kmaq, we've proven 2 separate sets of rights. But for some reason in this study, we've heard many people say that this legislation grants existing rights without any kind of wording in the purpose of this act that gets to that. And so I'm wondering, how do we balance trying to figure out the internal governance of the Métis without actually, you know, making sure that we're not doing anything around existing rights without going to the First Nations who might be triggered by a duty to consult with some of the things moving forward. Steve, I want to start with you, and maybe you can help me dive into your thoughts around that.
Well, this bill isn't about land rights or anything else. It's about Métis people to self-determine who their community is. We know historically that they had what do they call them? The road allowance people. You know, that's common knowledge across Ontario, and you know, and I agree with you. Government has been getting this wrong for well over 100 years. If not, I don't want to correct you, and maybe 150 or 170, but it's been getting it wrong for a long time. So, you know, let's get it right this time, I hope.
Chief McVicker, we've had the Métis organizations come to this committee and say that this is not about rights of land, this is not about rights to resources, and the drafters have said to us that any potential treaties that may impact First Nations would definitely have a duty to consult those First Nations. Do you disagree with that in terms of what the wording is of this legislation? And if so, can you point to the phrase in this legislation that would impact First Nations treaty rights?
Okay. Sorry, I'm thinking of the wording. It does say that it's opening the door in the bill to treaty negotiations, right? And so when you're talking about treaty, that's, like I said earlier, it's about land, and I don't think that. Let me see here. Excuse me.
I mean, just to help you out with that thought, though, but they said if there is an impact to First Nations lands or resources, that would trigger a duty to consult, and that which way First Nations would have to be consulted if there was ever the contemplation of that, which they've admitted to. If we put in something as an amendment that said that if this legislation impacts at all First Nations rights, that there has to be a duty to consult with those First Nations, would that be some agreeable amendment for you?
No, because there's a lack of due diligence, because you're You're giving them rights that did not exist and were not well established before effective Crown control in our area, and it's missing. You didn't talk to us at all, and it's missing our law. And we have Anishinaabe and Aquitaine when we have a governance structure that was existing prior to effective control, and we have not been consulted. So, I mean, it's not based on historical fact.
I guess the difficulty that we have, though, is that the Powley decision is based out of Ontario. How do we get around the fact that for 20 years we've established that Powley is law in Ontario and then asked to take out the Ontario Métis out of the only recognized Section 35 precedent in Canada?
Powley was about hunting moose, right? This is about self-government you're talking about, and you're talking about treaty. In the bill, it does say treaty. And you can't talk about treaty without talking about a land base. So Powley was about harvesting rights. And we have cases that we've taken to court, hundreds of them, about harvesting rights as well. So there's a big difference from us. And I did explain what we're having happen with all of the Anishinaabe nations is running into Ontario and Canada are already putting the Métis into consultations with us about land, about resources, about water, and it's just going to magnify that. It's just going to make it all that much more difficult for us to assert our rights, which are inherent. Yeah.
That takes us to the end of the 6 minutes. We'll go now to Madame Gill. Vous avez 6 minutes.
Merci, Monsieur.
You have 6 minutes. Thank you very much, Chair. Thank you to the witnesses for being here with us today. And I understand that this is a subject that is a difficult one, but necessary. And as I said for the first panel, I wanted to leave you some opportunity to give your opinions. There are those who are against the bill. There are those that are in favor, and there are opposing views. And would there be any amendments that you might recommend, be able to recommend that might address the fears, the controversy, to make the bill more acceptable? So I'd like to hear the three of you with regard to the position of those who are against or those that you do not agree with, and perhaps anything that might serve to address these differences. Mr. Mewasaki, Mewasaki first, perhaps.
So, I don't think it should start consultation now. Once it is passed, I think, and then that's when it starts affecting other First Nations. Then that's when consultation has to start. But it's not even to that point yet. So consultation starts after, when it starts affecting me. Then I expect them to come and talk to my leaders. I think that also that if we don't get this right this time, it could be another 150 years. My ancestors, my great-great-grandchildren not yet born, will no longer become an Indian. And I don't think that's right. I think my great-grandchildren, as well as anybody else in this room, your great-grandchildren would love to see what nationality they come from, whether you're, Italian, Greek, Chinese, whatever. It matters to everybody in this room. And I think in 150 years, if your ancestors said, hey, my great-great-grandmother, great-great-grandfather sat in that room and thought about me 150 years ago to protect my rights, they were thinking of me.
Yes. So thank you for the question. I'm going to speak more so specific to Alberta. I believe that there's a major discussion going on within the Métis Nation of Ontario, and I want to make sure that I speak to where my strength is, and that is my province. And what I will speak to is this: is I was a part of the negotiations and discussion in terms of how we as Métis people can have representation within Ottawa. And again, the entirety of the Indigenous population is under an identity crisis in Canada. It's not just specific to Métis people. But I do believe that we need to make very clear before any type of legislation moves forward that there needs to be limitations built in, but there also needs to be a higher level of criteria when it comes to awarding any type of Indigenous citizenship, especially when it comes to Métis citizenship. Would I be willing to consider amendments? Absolutely. I came here prepared to look at having that conversation. I came here prepared to look at how how this bill could be crafted to protect my community, and at the same time create carve-outs for other independent Métis organizations to have a similar conversation with Canada. Now, with that said, I can only speak to what I know, and I know the treatment that I've received from the Métis Nation of Alberta, and that's all I can speak to. And what I will say is this, is I have siblings, and I have my mother who are members of the Métis Nation of Alberta. So I am torn here because I'm representing my people, but I have my family. The reality is, though, I'm here to represent the community, the nation of Fort McKay Métis Nation. And what I would say is this, is there needs to be more work. I agree with Steve. We need to get it right. I know that we need to get it right, and the only way that we can get it right is through putting in the work. And the reality for me, though, where I do disagree with Steve, is that consultation. We need to get the cart before the horse in this circumstance. There should have been consultation leading through this process. There should have been dialogue with the people who are going to be affected through this legislation. And I think that, in my mind, is essentially what is hurting the entirety of the conversation, is the fact that there wasn't enough due diligence put forward when dealing with such a critical issue surrounding Métis rights, which will lead to treaties. Because, again, there are conversations in Alberta where First Nations are also asking questions about what does this mean for their treaty territory. Thank you.
There's not much time, perhaps, to hear Ms. McVicker. You could also send something in writing, if you like, to explain your thoughts on this issue.
So I have a bit of time or none?
I'll give you, if you can do it in under a minute.
Okay, well, as I said earlier, I don't think that there's a possibility of an amendment, and that this bill has a lot to do with land. And even if it were not about land, Canada has to do its due diligence to make sure it's not recognizing the Section 35 rights of groups who don't have the history that confers such rights. And Canada has not done this due diligence. So no amendments can fix this bill.
Okay, thank you. We'll go now to Ms. Idlut, who's joining us online. And Ms. Idlut has 6 minutes. The floor is yours.
Thank you, Mr. Chairperson, and thank you to the witnesses, because this is a very important matter that you have put before us. And what you are saying is very similar, because the bill is very important. I want to ask Ronald, it seems that you are saying, it sounds like when the federal government consulted with you in preparation for C-53, what you said was ignored. What did you say to them that was ignored? And what needs to be heard now?
Thank you for the question. And what we said within our consultation within our correspondence, to the federal government, was very clear that there needs to be a conversation. That there needs to be a conversation with Métis communities who are not a part of the Métis Nation of Alberta. There needs to be a conversation so there are protections built in. There needs to be a conversation so that when this bill comes to fruition, and when we reach this stage of the process, that we would have had an ability to entertain that conversation. We sent this multiple times, and again, the correspondence we sent was in opposition to the Métis Nation of Alberta, and strictly to that, because of the fact that we were under a constant threat in terms of the treatment of our Métis communities through litigation. Now, with that said, what we said to them, Madam Member, is that it's so critical that, and I will say that former Minister Miller had a conversation with us after they signed the self-government agreements in February, and he gave us 15 minutes. And what I made very clear to him was that the process leading up to Bill C-53 was not just sloppy, it was lazy, because there was not the work put in to be able to make sure that we can get this right.
Thank you. You have really clarified that excellently. Now I have a question to Linda. What expertise do you bring to know whether treaty leads to land rights?
Only from my own practical experience as a leader at the negotiation tables with Canada and Ontario since the framework agreement with the MNO and what we're facing. That's the practical experience that I've seen. Expert experience, well, I'm not an expert. I have a lawyer. I have advisors. I'll admit that. But it all comes back to not doing your due diligence and not being careful about who you're going into treaty with. And actually, you have an obligation to protect us from our inherent rights being infringed upon under Article 8 of UNDRIP. So I'll just stop with that, Miigwech.
Thank you. Now, I have a question for Steve now. Steve, I am so proud of you, and I want to work with you. You want to be united with other nations, with nations, First Nations, Métis, and the Inuit. You are right. We need to be united together. How can we have more solidarity as Indigenous peoples of Canada?
Kind words. Thank you. Thank you for those kind words. I agree. What we need to do is sit down and talk, people to people, not nation to nation. We need to sit down and talk about who we are, how everybody's been affected by this. We're affected by the opioid crisis. We are affected by water. We are affected by murdered and missing women. Nobody draws the line on that. Nobody can say that, oh, you're more affected than I am. We're all affected the same. Just like, the Indian Act, it treated us all the same way. It was you who decided about residential school. It was you who decided, everything that has brought us to this table today. And it is you people that now can say, we got it right this time. We passed Bill C-35, and now all three nations are working together. And I think that's what it'll take to make us work together, all three nations.
Lori, you're out of time. The alarm is going. So I'm going to move now to Mr. Zimmer, who has the floor for 5 minutes. 5 minutes.
Yeah. Thank you, Mr. Chair. And I just wanted to start off by saying that's a great part about this particular committee, INAN, Indigenous Northern Affairs Committee. It's a place for Indigenous communities to be heard. And we know Indigenous communities are struggling this very day because of the carbon tax. We have heard from First Nations, Métis, and Inuit leaders across Canada that it is a challenge for their communities. An article from this week, Ontario Indigenous Group wants exemption on the carbon tax. Chief Abram Benedict says policy is unfair to Indigenous communities. And a similar comment from a Métis group from the Northwest Territories. What this carbon tax does is cost Indigenous families who are struggling more, and a real simple message of axe the carbon tax. Another message from another leader, this particular leader is an Inuit leader from Nunavut, a former MLA for Nunavut, who says her Inuit priorities are carbon tax affecting Nunavut cost of living. And that's what brings me to the motion before us today that I've made notice of as of Tuesday. So that pursuant to Standing Order 1082, given that the Ontario Grand Chief Abram Benedict of the Akwesasne First Nation says the carbon tax is an unfair policy for Indigenous communities, that the committee undertake a study of 5 meetings to examine the impact of the carbon tax on First Nations. And I understand that there's a friendly amendment being offered by Ms. Idlow to add a few groups. Tax on First Nations communities across Canada, that the Minister of Crown Indigenous Relations and the Minister of Indigenous Services appear, and that the committee seek additional resources in order to accommodate these meetings. And speaking with Ms. Idlow, we've spoken about adding Inuit and Métis to this particular motion, so it's all inclusive. So I'll move that, Mr. Chair. And again, if Ms. Idlow has a comment to make about her friendly amendment, I'd like to give her some time to do that.
Okay, I'm setting up a speaking list. I have Mr. Batiste, Mr. Viersen, Madame Gill. So we'll start with those three. So, Mr. Batiste, over to you first.
Well, first off, I want to apologize to the witnesses that this testimony has been sidetracked with this motion. I respect that you guys have done a lot to get here to testify. I apologize that sometimes these things happen at committee where necessarily the committee study takes a backseat to the agenda of a certain party. But with that, I want to say that I think that we should call this to a vote.
Okay, thank you. I need to go through the speaking list. So I'm going to go to Mr. Viersen.
Yeah, thanks, Mr. Chair. I would just apologize on behalf of the Government of Canada that they are unable to tax Canadians equally across the country, and that's what this motion is about, ensuring that the carbon tax, home heating fuel is not taxed across the country. I'm happy to vote on this motion.
Okay, Madame Gill and then Ms. Idlow.
Thank you very much, Chair. I didn't have an opportunity to speak with Mr. Zimmer, but I would have some amendments to make. And the first is that just before going ahead, I would like to apologize to the witnesses, but the issue of representation of First Nations in your motion asks that we call on the minister, and without referring to the First Nations, or the Inuit, I think we can't speak for them. They have to speak for themselves, and so this is a failing in your motion that doesn't include some of the people who are most affected. And then when you talk about the carbon tax, of course, there are other chiefs who have talked about the effects of climate change on their communities. I'd like to know what are the impacts of climate change on the various Indigenous communities that we've heard about here in the committee, and perhaps they could talk about the carbon tax, but this is also a problem with climate change. And with regard to the issue of budgets, I think that is something that is something that's important for the whips, and I think these are issues that I would like to highlight with regard to this motion.
To be clear, before I go to Ms. Lute, are you putting forward any amendments to the...
Il y en a déjà un, je pense, qui a été proposé. J'ai pas...
I think there's one that's been suggested by Ms. Lute. I would also perhaps have amendment. I don't know if it's been sent or not, or it's already been. I think that the motion it may have been already sent.
Yeah, the motion from Tuesday was distributed, but none of the amendments have been.
Non, c'est ça, mais je les ai. Donc je peux les...
No, but I can send them to the clerk.
Lute, the floor is yours.
Thank you, Mr. Chairperson. I just want to verify that what Mr. Zimmer said about meeting or talking about this with him, and because we both agreed that Métis Nation should be included, and if we're going to be voted on it, then I would say yes to an amendment. I would vote on it if there was an amendment. Thank you.
Are you making that amendment? Just needing clarification, because if we have an amendment, then we need to deal with the amendment and then the motion as amended. And so, Ms. Lute, are you putting forward an amendment at this time?
Yes, I would want it amended to state that Inuit and Métis Nations be included with the First Nations, to be amended as such. Thank you.
Let's have Mr. Zimmer and then Mr. Batiste.
Yeah, thank you, everybody, and again, appreciate your comments. Ms. Gill, just to answer your question, all these groups would be witnesses would appear to tell their story. Again, it's all about having their voices heard, like we've been hearing ourselves. So it's a place for them to come to committee to have their voices heard on this particular issue.
Okay, I'll go Mr. Batiste. Laurie, I'm not sure if your hand is still up from the first intervention or if you're wanting to get back on the list. Okay, Mr. Batiste.
Making a motion to adjourn debate.
Okay, that then becomes a votable motion. So I'm going to call the vote on adjourning debate at this point. So all in favor?
You might want to go around because I don't think the people virtually are seeing what you're doing.
Yeah.
Oh, okay.
On recording division?
Do you want it recorded?
Debate, right?
Okay. Yeah, I don't know if everybody's...
The motion is to adjourn debate.
Yes.
Mr. Batiste?
Yes.
Mr. Carr?
Yes.
Madame Fortier?
Oui.
Mr. McLeod? Is he?
Yes.
Ms. Atwin? Yes. Mr. Schmale?
No.
Ms. Goodridge?
No.
Mr. Viersen?
No.
Mr. Zimmer?
No.
Madame Gill? Oui. Ms. Idlout?
Aka.
Nope.
I'm sorry, what was the... No. 1, 2, 3, 4, 5, 6 yeas and 5 nays.
Okay, so the motion to adjourn debate has been carried, so this will remain on the books. And when it comes back, we will have the amendment to deal with. I had also previously ruled that when motions are brought forward and the clock's running, we let it run. We've reached the end of the 5 minutes, and so now we'll move to, we actually have resources till 5:35. And that doesn't, anyway, the next on the list would be Mr. Carr, and we would have, yeah, okay, point of order, Mr.
Is there a way just to extend it so each party gets to finish off their round?
We have resources until 5:35.
So that's,
Okay, all right.
okay, so, okay, it's actually Mr. Carr's turn. Oh, okay, Mr. Batiste.
Chief McIver, you said that treaties all have to be about land. The peace and friendship treaties in the Atlantic don't speak to land at all. How can you say that if we're talking about treaties in Canada that have to talk about lands when the peace and friendship treaties don't mention land at all?
Well, that may be, but from what I've witnessed, this is going to be about land because it's already being brought forward at the consultation tables.
But you do realize that there are treaties, First Nation treaties in Canada that don't mention land, correct?
I'll have to take your word for that, but this is not what this one is about. Okay. I beg to differ about this one.
So the presumption is that this is a treaty and this will be about land without having that actually indicated in the legislation.
I'll tell you again, based on my experience, that they're definitely talking about land on a regular basis, and they're also talking with proponents about getting into resource agreements. It's clear and evident that they are, and they're purchasing land. So, just to talk about
Chief, I'll leave it at that. We'll leave it at that. We don't have too much more time.
Yeah, that's okay. We can leave it.
That's the only question I have. We only have 1 minute, so.
Yeah.
You know what? Yeah, we're not going to probably get into another question, so I'll take the last minute just to thank our witnesses and thank you to the three of you for joining us here today. We were able to confirm a bit of a mix-up with our fourth witness for today, and so we will be submitting a request if she would like to send us a written brief. And for the three of you, if you do have additional thoughts based on the conversation today, we can take up to 10 additional pages in written material, so please feel free to weigh in with additional comments. And with that, colleagues, I'd like to wish everyone safe travels home. I hope everybody gets to Remembrance Day ceremonies, safe Constituency Week, and we will see you when we get back in a week. And right now, we are meeting adjourned.